Hey, good afternoon, everyone. I am delighted that you're able to join us for our webinar today. I am Dr. Jennifer Peel, and I'm the director of the University of Washington's Center for Mental Health Policy and the Law. And you're joining us today for one of our excellent talks in this Hot Topics in Mental Health and Law webinar series. It's focused on civil commitment, and the topic today is navigating juvenile involuntary commitment in Washington State. I'll get a chance to give a little background about our speaker, Shawgi Silver, in just a moment. But before I do that, we're going to go over some logistics and some background about the talk today. So for those who don't know about our center, the Center for Mental Health Policy and the Law is housed within the University of Washington's Department of Psychiatry and Behavioral Sciences at the UW School of Medicine. The center's mission is to address the most urgent issues arising at the interface of mental health and the law in order to help justice-involved people with mental illness lead full and productive lives. And if you're interested, we encourage you to visit our website for more information about our programming and offerings. This is lecture number 6 in this Civil Commitment webinar series. And you'll see that we have a couple of additional topics coming up soon. In May, we'll be talking about policy related to civil commitment, and Senator Dhingra will be joining us to give that talk. And then in June, we are inviting all of the panelists from our series to return with us for a nice discussion and opportunity to answer and ask questions of the panelists. Now, this session is being recorded. The recordings and the presentation slides will be made available on our website within a week. We will email all attendees with the link so that you know that it's available. Continuing education is available only for attendees who attend the live Zoom session, not for those watching the recording only. Certificates of attendance will be available for attendees who interact or have expressed interest. You'll receive an email from the center with these additional details. And you should know that continuing medical education is available. For those who are UW faculty and staff, you'll receive an email from the center with instructions, and you'll need to sign in via text by 2 p.m. For all non-UW learners, we track attendance via Zoom, and you do not need to log in or update your name on Zoom, as the attendance is tracked according to your unique Zoom link. About disclosures, today's speaker, Shawgi Silver, has no financial relationships with an ineligible company relevant to his presentation to disclose. In fact, none of the planners have relevant financial relationships to disclose with any ineligible companies whose primary business is producing, marketing, selling, reselling, or distributing healthcare products used by or on patients. We will be fielding questions at the end of the talk today, so please use the Q&A icon in Zoom. And also, for any questions we don't get to actually field today, we are banking all of our questions, and we hope to be able to pose these questions at that final June session within our webinar series. Some final logistics. It's important to know that the opinions expressed in today's talk are the views of the speaker and do not reflect an official position of the center or the University of Washington. No official support or endorsement of the opinions described in this presentation come from the center or UW, or is intended or should be inferred. Automated captions are available in the meeting control toolbar. Just click on Show Captions. And also at the end of the session, there'll be an opportunity to provide some poll information, and we encourage you to do that. With that, it is my great pleasure to announce today's speaker. Shawgi Silver, MD, MPHS, obtained his medical doctorate from Washington University in St. Louis, the School of Medicine there. He went on to earn a Master's of Public Health Sciences prior to completing medical residency at the same institution. He specialized in child and adolescent psychiatry with a concentration in neurodevelopmental disorders at Seattle Children's Hospital, And then he completed an additional fellowship in forensic psychiatry at Oregon Health and Sciences University. He does work in workers' compensation, disability claims, fitness for duty evaluations, tort claims, and competency evaluations. His experience with testimony and depositions is an additionally distinguished feature of his medical legal work. And I'm just delighted to have this expert with us today who has both experience in child psychiatry and forensic psychiatry. And I'm just very delighted to be hearing his presentation. So I'll turn it over to Dr. Silver.
That's excellent. Thank you so much, Dr. Peel. It's a very gracious introduction. And as you heard, I did my child and adolescent psychiatry training here at the University of Washington and Seattle Children's Hospital. So I'm delighted to be back here with you all to discuss this very important topic of juvenile commitment. And I want to thank you for joining and thank you for allowing me to give this presentation. Honestly, I'm honored and humbled to share this virtual stage with giants in the field like Dr. Peel and Dr. Candelas and all of the other educators and clinicians, evaluators and servants of our community. So with that, we'll get into the presentation itself. So my goal in this lecture is to provide an idea of the framework that I and other child and adolescent psychiatrists use in approaching this frequently challenging and often very thorny issue of youth civil commitment. So this is meant to be a practical overview and not an exhaustive unpacking of these very complex and intersecting concepts of medicine, developmental biology, developmental psychology, the law, state statute, hospital policy, and other fields. So the main idea here is to share the perspective of a child and adolescent psychiatrist to give you a sense of some of the foundational concepts that I draw from when considering commitment of children and youth. So by way of a roadmap, here's the general path that we'll take in the course of this talk. We'll start off with getting an understanding of the legal framework, and that's governed by RCW 7134 and other aspects of RCW 71, and the family-initiated treatment, or FIT, formerly known as parent-initiated treatment, or PIT. We'll then also talk about the balance between minor autonomy, parental rights, and state intervention in psychiatric care, which is an evaluation of the ethical and clinical considerations of this topic. And then, of course, we'll use a case study to determine appropriate legal pathways and alternatives to hospitalization, which is going to cover this third point, which is the application of this knowledge to clinical cases. So Dr. Peel and the department really have structured this lecture series in a very beautifully congruent way. So by way of a brief review, let's see where we came from and use that to help us get to where we're going. So we started off with the legal concepts of civil commitment covered by Shadow Jones. So the practical work of designated crisis responders was then covered by Don McCready-Santos and Laura Pippin. And then, of course, we had the history and ethics of the process of civil commitment, which was really masterfully taught by Dr. Candelas. And then we got the invaluable insights of the lived experience of civil commitment by Laura Van Tosh, Karen Schilde, and Carolyn Panzoja. So all of this groundwork sets us up perfectly for a deeper dive into how civil commitment applies to children and adolescents in Washington State, and also how that compares to the adult civil commitment process. So my hope here is to leave a generous amount of time to have a more open dialogue after the slides, because learning from each other, especially the lived experience of patients, families, and other clinicians really has great value. And in listening to others, I'm excited to expand my own understanding of how others look at this topic. So let's talk about Emma. So when I met Emma, she was 15 years old, and she was brought to the emergency department by her parents after a suicide attempt. And this was a genuine attempt. It was one that didn't require general medical stabilization, but it was one that was serious enough that without her parents' intervention, it most certainly would have led to either her death or to very serious disability. So she had struggled with severe depression for many years. Her parents struggled to get her help as best they could, and ultimately they were desperate enough to keep her safe that they sought inpatient treatment. Now, this would have been Emma's first psychiatric admission, so she was understandably scared about being away from home, losing contact with her friends, and thinking about what the kids at school might say, as well as the stigma in general of a psychiatric hospitalization. So Emma was bright and clever, and she was pretty well informed. So she knew that she could refuse, insisting that she wasn't a danger to herself. And she also knew that given her age, she was able to make decisions about many of the aspects of mental and reproductive health for herself. So despite a long discussion with her about the benefits of hospitalization, including more rapid titration of her medications, ensuring her safety, allowing more time to get a comprehensive outpatient plan put together, she continued to refuse. And as always, it was a very busy evening in the emergency department, and this matter, along with several others, was very time sensitive. So the question then, of course, is what do we do? So Emma's refusal put us face to face with the very tough decision of balancing autonomy and safety. So should a 15-year-old have the right to refuse life-saving treatment? And then at what age in Washington State is a juvenile responsible for their own mental health care decisions? And then how do we balance protecting a minor with respecting their autonomy? And then, of course, what role do parents play in gaining access to psychiatric treatment for their children who are between the ages of 13 and 17? And then this really is just a handful of questions that we could ask ourselves. So at the end of this talk, you'll be able to answer these questions. And you'll be able to do that with a fair amount of sophistication, weighing many of the pros and cons that exist in the gray areas that lead to the fundamental challenges that we face at these moments of intense and necessary decision-making. As clinicians, we have the very awesome and weighty responsibility of safeguarding and promoting a child's or youth's health and well-being. But there are times when this responsibility puts the medical opinion of a patient's best interests, as far as we deem, at significant odds with the patient's voiced preferences. Safety is one of those times. So this includes safety of the patient, safety of the family, safety of the community, among other considerations. So we're tasked with performing this very delicate balancing act at the very height of peaked emotions, psychiatric decompensation, strained family relationships, and medical crisis. So developmentally, adolescence is a time of normative questioning of authority, testing boundaries, taking risks, preferencing friends to parents, and allying with peers. All these behaviors are normal. But these normal behaviors can pose serious and sometimes very life-threatening consequences and second-order effects. And this is especially the case in this age of social media, online bullying, lightning-fast communication that can't practically be monitored by parents, remarkably potent illicit or misused substances, and the general mistrust of authority and the educated that has become so pervasive in society at large. So looking at this fourth bullet point here, what's so special about 13? So reaching the age of 13 grants reproductive and mental health rights in Washington State versus 18 years old in most states, which is the age that grants all of the guarantees enshrined in the Constitution for the age of majority. Now, a lawyer asked me a while ago, so what's so special and magical about this 13 years? And aside from being part of the title of a delightful and whimsical movie starring Jennifer Garner in the early 2000s, and if you somehow missed it, I highly recommend it. There really is nothing in developmental biology that I'm aware of to indicate that there is a significant change in the functioning of the adolescent brain between 12 years old and 13 years old. But there is some merit to the idea that developmentally, a 13-year-old does have prefrontal cortex functionality and more developed hippocampus functioning than an 8, 9, or a 10-year-old does. So there is some justification to why it is that lawmakers came down at the age of 13 to set this age of decision making, at least as far as psychiatric care and reproductive health goes. So how do we begin to untangle this Gordian knot of autonomy and safety? Here we look to first principles. So the four core principles that come up most often in medical ethics in the Western world can be traced back to Hippocrates and the famous Hippocratic Oath. So you've likely heard about this oath. At the beginning of our training, all physicians are required to take some variation of this oath, which is rooted in that original Hippocratic Oath. And at least in spirit, we're meant to be bound by it in the same way that physicians have been for thousands of years. The oath is meant to instill the concept that our highest duty is to the patient and that we discharge that duty in the most ethical way possible. And to do that, we have these underpinning ideas: autonomy, beneficence, justice, and non-maleficence. So we frequently refer to these core principles as the four pillars of medical ethics. So let's do a deeper dive into these four pillars. So these foundational concepts were articulated and popularized by Tom Beauchamp and James Childress in their book, The Principles of Biomedical Ethics. This was published in 1979. Autonomy is the preeminent principle, the one ring to rule them all, if you will. It's the guiding philosophy of American governance, and it's contained in the concept of individualism. It's essentially the idea that the patient's right to make informed decisions about their own healthcare really is the overarching concept that we're attempting to serve when we're serving the patient. So autonomy really is at the very heart of how we, at least in theory and foundation, organize medical care and American life, law, and society. So we greatly value this concept of freedom and individual liberty in American society. So we're compelled to find out, what is the voiced preference of the patient? Is it possible to serve that preference in a safe manner? And if not, what are the barriers? And what can be done to preserve the spirit of the voiced preference, even if there's not a way to serve that voiced preference directly? So these questions really are the beating heart of the legal oversight in medical decision-making that infringes upon or restricts the individual liberty of a given individual. This process of oversight prevents physicians and medical establishment from overstepping. So even when we have the best of intentions, history, very unfortunately, is rife with examples of physicians going too far in this paternalistic or parentalistic attempt to help people. Dr. Candless introduced us to the extended hospitalizations of Josiah Oakes and more recently Kenneth Donaldson. And both of these cases and others powerfully influenced how we address involuntary commitment today. And then we have the concept of beneficence. So this refers to the doing of a good thing or producing good from a specific act. It's not a word that we commonly use in our daily interactions. It comes from the Latin beneficus, bene meaning well or good, and facere or facere, depending on ecclesiastical or classical Latin, meaning to do. So we think of this as doing the right thing. And as with most of these concepts, there is an element of relativity or subjectivity in deciding what is good or what is right. So what's right for one person in a certain situation might not be right for another person in another situation. So here we can borrow the legal concept of a reasonable person or the reasonable person standard. And this is the idea or the thought experiment that you can ask yourself, what would a hypothetical reasonable person think of as the right or good thing to do in this situation? One very beautiful thing about these four pillars of medical ethics is that they each support and temper the other. So the right thing is tempered by preserving the autonomy of the individual. So even if we think that a thing would be good for someone, is that thing what a reasonable person would consider for the good of the patient? And most importantly, does it fit into what the patient would want, which is autonomy? Then we move on to the concept of non-maleficence. So this is avoiding causing harm to the patient. So it's doing our best not to cause harm. So the widely recognized and often quoted idea that a physician must first do no harm, which comes from the Latin phrase primum non nocere, is not actually part of the Hippocratic Oath, even though, again, it's generally thought of as being part of it. Despite this, it's understood that we must try to minimize harm and potential for harm in all of our dealings with patients to the best of our ability. And this includes minimizing the intentional restriction of their freedom when it's possible not to do so. So this is the foundation of the least restrictive environment requirement in planning the disposition of patients. So in the course of our treatment of a given patient, we have to always justify that we are doing what provides the least restrictive environment possible while keeping the patient safe in the context of their behavioral or mental health condition. And we can finish this up with the idea of justice. So justice is treating patients fairly and ensuring that healthcare resources are distributed fairly in an equitable fashion. So this is the attempt to make things fair in both access as well as the delivery of treatment. So there should be a justifiable reason for deviating protocol in one patient compared to another, or in providing one patient a certain thing and denying it from another. So the legal principles that apply to the commitment of minors are mostly the same as for adults and are protected under the majority of the 14th Amendment. But it's also important to note that not all elements of the 14th Amendment or the 5th Amendment, for that matter, are guaranteed to youth. So Shadow Jones' talk covered the foundational legal principles of parens patriae and police powers. So these are the two twin legal doctrines that give the state the authority to restrict the freedom and civil liberties of an individual for prescribed periods of time, typically for the safety of the patient and or society. Both the constitutional guarantee of liberty under the 5th and 14th Amendments of due process and equal protection under the law, as well as the guiding principle in medical ethics of autonomy, require that clinicians prioritize the least restrictive environment while serving the principles of beneficence and non-maleficence, as we saw just a moment ago. So as foreshadowed above, not all elements of the Constitution apply to minors. And the reason is that the government assumes the role of protecting a minor's welfare over and above the protection of the public good as applied to adults under the doctrine of parens patriae. So some of the constitutional protections are not guaranteed to youth, and those include things such as the right to a jury trial, the right to a grand jury, the right to a speedy trial, and other elements. So now that we have an idea of the competing interests at play, we have a greater appreciation of what elements we need to balance in this great balancing act. So it's the competing interests of the needs of the family versus the needs of the youth, autonomy versus beneficence or non-maleficence, constitutional rights versus medical ethics, public safety versus individual rights, a parent's responsibilities to their child versus the youth's preferences for how they're going to conduct their own life and make their own decisions. The youth's voiced choice of treatment or treatment environment versus the medical opinion of the ideal treatment course or environment for treatment. And we can see that, again, many of these are at direct loggerheads with the other and serve very different but equally important needs, wants, and desires. So, the ITA criteria. So with regard to the behavioral health disorder that's mentioned in the ITA criteria for minors ages 13 to 17, the RCW 7134-020 specifies that there be a behavioral health disorder. And it's important to know that a minor can't be involuntarily committed solely for substance use, for behavioral issues or family conflicts, or even just frank violence, unless there is indeed a co-occurring behavioral disorder. In practice, this typically translates to a mental health diagnosis that substantially impairs a person's cognitive, emotional, or behavioral functioning. And the burden of proof is on the evaluating professional. So that's to say physicians, designated crisis responders, social workers, to demonstrate that the minor meets the criteria for a behavioral health disorder, as well as one or the other of posing a risk of serious harm to themselves or being gravely disabled due to their mental health disorder or their behavioral health disorder. And again, simply engaging in unsafe behavior, so reckless action, substance use, aggression, without a diagnosable behavioral health disorder, does not meet the legal criteria for involuntary commitment. And as discussed in previous talks, this creates a host of problematic situations which we encounter regularly. And this is that individuals and families frequently find themselves in positions in which they have a patient who may not be sick enough to qualify for treatment, but they're not well enough to function. And then with regard to this concept of a minor. So if a child is younger than 13, parents have full authority over that child, including commitment and other medical decisions. So involuntary commitment for juveniles, or the so-called ITA. So we can start off with the initial detention. So beyond the standard voluntary admission, there are three avenues to admission that we'll explore. The first that we'll explore is here with the ITA as applied to minors. So a designated crisis responder can detain a minor for up to 12 hours for evaluation. And if the criteria are met, the minor can then be held in a certified evaluation and treatment facility for up to 5 days, excluding weekends and holidays. So in Washington State, a DCR, again, a designated crisis responder, is required in order to detain a youth. So we learned about this in one of the previous talks. The rules can be quite different in other states where oversight in the form of judicial oversight comes in pretty well after the initial detention. So for example, as you heard, I did my medical school training and residency in Missouri. So there, the initial detention for an adult is performed by the physician, and then the case goes before a commissioner for judicial oversight after the first 4 days of that initial detention and treatment. For anyone under the age of 18 in Missouri, the parents retain that full medical decision-making authority, except in very specific situations. So one element of this balancing act between civil liberty and medical necessity in our state has taken the form of separating the medical opinion for the need for involuntary commitment from the ability to perform that detainment. And there are pros and cons to this approach. Discussing them really could fill an entire talk by itself, and it's beyond the scope of what we're going to discuss today, but it is interesting and worth thinking about as well. So in terms of the ITA aspects, again, we can get into the nuts and bolts of the process here. If we want to go beyond that initial detention period, then a physician must petition for further time. That petition takes the form of a 14-day commitment petition, which is filed, again, if the minor still meets criteria for commitment and needs additional treatment. That requires a court hearing within 72 hours. The minor is entitled to legal representation, and then the parents or guardians have to be notified, but can't override the minor's legal rights. And then if there is additional need for treatment as far as the treating team is concerned, then a subsequent 180-day commitment petition must be filed. And if continued treatment is necessary, the court may approve that longer period, but it requires clear evidence that lesser restricted alternatives, so the so-called LRAs, are insufficient. So in terms of the rights of minors in the involuntary commitment process, due process is constitutionally guaranteed and rooted in the 5th and 14th Amendments. So these include things like the right to legal representation, the right to challenge a commitment, the right to request a less restrictive treatment option, the right to confidentiality with certain legal exceptions. And then it also outlines, at least in concept, the role of parents and guardians. So parents have the right to be involved, but can't unilaterally discharge a minor under the ITA. And then, of course, parents must be notified of proceedings unless it poses a harm or a risk of harm to the minor. So another avenue for a form of civil commitment is family-initiated treatment, or FIT, formerly known as parent-initiated treatment, or PIT. So what can a family do if there is medical necessity, but the bar is not cleared for involuntary commitment? Here, the idea of family-initiated treatment comes in. So as you can see here, it's a way for parents and youth to seek out behavioral health treatment. It gives them the option to access medically necessary inpatient, residential, and outpatient services. It requires a periodic review for legal safeguard for the youth's civil liberties and applies only in cases of medical necessity. So although this is technically a voluntary process, voluntary meaning by parent consent, the youth typically view this as an involuntary process because it does indeed deprive them of their freedom, their ability to exercise their liberties, and it temporarily takes away certain rights. So for that reason, there is a periodic review that ensures that there's not an overstep of medical providers or parents in this deprivation of the liberty and the autonomy of the youth. So parents, again, provide consent on behalf of the youth. Under FIT, parents can provide consent, and the consent of the youth is not required. But the youth still must meet medical necessity before treatment can be initiated. But again, this doesn't require the same high bar criteria set forth in the ITA process. And FIT creates an additional access point and doesn't guarantee care on demand. And this is because FIT is only available when there are available beds. So given the chronic shortage of mental health providers, mental health facilities, and mental health resources that we're facing as a country, really it's often the case, if we're being transparent, that beds are not available. And this creates a challenging situation in which the youth may be waiting in an emergency department while social workers are making the rounds trying to find an available bed in one county or another. So in those instances, clinicians must weigh the options available that will provide the safest possible treatment, given what we have at hand in terms of resources. So in summary, FIT is family-initiated treatment governed by RCW 7134, and it allows parents or legal guardians to admit a minor, so someone between the ages of 13 and 17, for inpatient treatment without their consent. It does not require a court order, but the minor must undergo periodic clinical reviews to determine if hospitalization remains necessary. Minors can petition for discharge after that initial review. So the next avenue for commitment is a voluntary one, and it's referred to as adolescent-initiated treatment, governed by RCW 7134. Here, minors can voluntarily admit themselves to inpatient psychiatric treatment if they're between the ages of 13 and 17. And again, they can voluntarily admit themselves to this form of treatment. Parents can also seek treatment for their minor, even if the minor refuses. And again, this puts us back onto that path of the family-initiated treatment that we saw before. And then a minor can request discharge because of the fact that they essentially admitted themselves. They can request to be discharged, but at that point, a medical professional must determine whether they still require treatment. So Dr. Candace walked us through many of the core ethical considerations with his analysis of principalism, vulnerable people and values, and the dignity of persons, ultimately leaving us with a concept that human rights theory should be at the core of civil commitment ethics. And that really is a well-rounded and wise perspective to take. One thing that often helps me when I'm approaching the ethics of a given admission is thinking about this balancing act again, from the context of the idea that it really is a wider context that we're operating within. So this is just one segment of the youth's life. And so what we do ripples into the future of this young person's life with regard to how they view mental health, how they interact with the medical system, how they view doctors, how they view their own mental health and mental health journey. So these are very important considerations. A concept that's also been very helpful for me is to consider that we don't need to worry alone, as John Ortberg once said. So medicine, it really is a team sport, and it's chiefly based in negotiations. I was given a similar piece of advice by an attending in medical school, and it really stuck with me. It transformed my interaction with patients, with families, with other providers, because viewed in this way, we can see that although overriding a minor's treatment refusal is a serious matter, we are making that decision by drawing from the wisdom, the experience, and the perspective of other individuals who have the well-being of the youth in mind. So we can and should enlist the help of others in our thinking and decision-making at these times. And then, of course, we must keep trauma-informed care in mind. So this idea of second-order and even third-order consequences really is essential, because we have to make certain that we're not doing more harm than good in compelling an admission. So we want to gain as much perspective as possible from other clinicians, from family, from the youth, again, viewing this as a team sport. And really, we want to make sure that we keep the autonomy of the youth in a respected light. So even if they're part of the team making this decision and their voiced preference is overridden, they have to know that their well-being is in mind, and that the benefits of admission really do outweigh the drawbacks. And really, the benefits of admission are greatly lessened if it becomes a traumatic or re-traumatizing experience to this young person. So here we can learn from the incredibly helpful and educational insights that were so kindly offered by the lived experiences talk, in which the patient experience was so beautifully articulated for us. So we should be very grateful to have gained those insights. I certainly am. And then we have to keep in mind this idea of cultural and family dynamics, of course, when we're making these commitment decisions. So we can consider enlisting the help of an interpreter, a navigator, an ethics consult, among others. So we have alternatives to admission. We have crisis intervention and stabilization services in the form of respite care or the mobile crisis teams. We have IOP programs and PHP programs. And there are community-based treatment options, including the WISE service, so the wraparound with intensive services, therapeutic foster care and respite, mobile crisis response teams, and peer support and family support programs. But we have to be cautious. And that's because hospitalization can resolve issues, allow time to plan, and ensure safety in ways that these options, as excellent and very frequently useful as they are, cannot serve. All right. So after all that, let's finish on the story. So after a long conversation with the hospital psychiatric team, Emma began to realize the depth of her struggles. And though she was hesitant, she decided that she would voluntarily admit herself under AIT. Over the course of the next several weeks of her treatment, she worked with the therapists, the coaches. She started medication, and she joined other teens dealing with depression. And with time, she gained coping skills and sense of control over her recovery from this acute episode. By the time she was discharged, she felt hopeful for the first time in years and began working on rebuilding her relationship with her family, who also received support and education about her mental health. At Seattle Children's Hospital, we have the benefit of a very strong psychologically minded treatment team. So this is beneficial in that it helps teach skills and tools as opposed to just focusing on medication management during the youth's time in the hospital. So the morning huddles that we had and continue to have include social work, nursing, physicians, and the group programming emphasizes teaching skills like distress tolerance. So we also have the benefit of a uniquely large facility at Seattle Children's. So the patients are stratified by their age group. They're able to continue going to school. They have a lot of programming that's geared towards, again, gaining these skills and coping mechanisms. And they can have a lot more involvement with their parents during their course of treatment than other facilities are frequently able to offer. In an alternate universe, Emma continued to choose not to be admitted. And so the designated crisis responder determined that Emma met the criteria for involuntary commitment due to the severity of her suicide risk. She was initially very angry and fearful, but the structured inpatient care helped to stabilize her depressive symptomatology. And then over the course of the next 2 weeks, she received therapy, medication adjustment, and supportive care, and slowly she began to feel relief from the overwhelming hopelessness and despair that was consuming her. So ultimately, when she was released, she transitioned into a PHP program and continued outpatient therapy. And then a year later, she was found to be thriving in school, reconnecting with friends, and even helping others by volunteering for a youth mental health advocacy group. And in our third possible scenario, Emma refused treatment, but her parents, recognizing the need for inpatient admission, utilized the family-initiated treatment pathway to admit her to the hospital. So although she was resistant at first, she eventually opened up to a treatment team, and she was able to understand that her parents' actions really came from a place of love and concern. And so over the next few weeks, she started to feel better. She found comfort in journaling, music therapy, and group sessions, and she was working on her communication through family therapy to resolve that rupture that had occurred with her parents. Upon discharge, she expressed gratitude that her parents fought for her when she couldn't fight for herself. And a year later, she was in a much better place pursuing her dreams of becoming a counselor to help other struggling teens. Now, these three scenarios assume high-quality trauma-informed care. So we have to acknowledge that this ideal often differs from many patients' and families' lived experiences. With our limited inpatient resources, the chronic bed shortages, and limitations in step-down care. So we heard a little about this in the lived experiences talk. Now, that is challenging, of course, but it also highlights the value of these resources when they are deployed judiciously. So the medical literature presents mixed findings on the effectiveness of these involuntary hospitalizations. So while involuntary commitment can be life-saving in crisis situations and therefore absolutely essential, it also does raise ethical concerns, as we discussed, and outcomes do vary depending on factors like length of stay, the severity of the illness, comorbid medical conditions, the number of prior hospitalizations, post-hospitalization support, family structure, and individual patient characteristics, among a host of other things. So we recognize that studies suggest that crisis stabilization and immediate risk reduction really are the key benefits of inpatient psychiatric care. However, many studies highlight the negative psychological impact of involuntary hospitalization, including feelings of helplessness, mistrust, and trauma. So the adolescents who experience coercion in psychiatric settings may be less likely to engage in voluntary mental health care in the future. And this again highlights the need or the very useful process of engaging that youth in such a way that they feel that they are part of a team that is making this decision. So involuntary hospitalization alone doesn't guarantee long-term improvement in mental health outcomes. But research does suggest that inpatient admission followed by post-discharge services like intensive outpatient care, family therapy, and community-based interventions does have a high likelihood for sustained improvement. So involuntary hospitalization can be crucial for crisis stabilization, but it's not a standalone solution for juvenile mental health. And these key takeaways, I think, are going to be very helpful, just guiding some thinking down the road. The ITA provides strict criteria for juvenile involuntary commitment in our state. We recognize that minors have a legal right and several rights that must be upheld during the process. There are ethical considerations at play, and a major role in decision-making is indeed played by these ethical considerations. And then there are alternative interventions that we should always be exploring before commitment and even during this process of continued inpatient care. And trauma-informed care is an essential aspect in any ITA process. And so, as in all great journeys, we end where we began. So here are our objectives. And my hope was that this gave some helpful insight and background in order to think through understanding the legal framework, evaluating the ethical and clinical considerations of youth commitment, and then applying that knowledge to clinical cases, specifically Emma. So please do reach out to me if there are any questions at all about any of the material here that was presented, or anything that I can help clarify in advance of the panel discussion that we're going to be having in June. And here are some resources that are also helpful. But as I said, it's helpful for me to consider medicine as a team sport. So I will leave you with that concept. And with that, we can end the talk. So thank you very much for your time.
Wonderful. Thank you so much, Dr. Silver, for such an informative talk. I really appreciate how you were able to walk us through the various pathways that a youth might undergo to be hospitalized, and a little bit about what that might look like as well. We do have a number of questions already posed to the Q&A, so I'll start off with some questions there. But before I start asking some of the questions, I noticed that several of the questions ask about the availability to get these slides and to see the talk again. And I just want to remind any participant that the slides and talk will be posted to our center's website within about a week. Okay. The first question here asks about actually emergency detention in the field, particularly by law enforcement. And can you share any insights about that process for youth and how they might be detained by law enforcement before ever making it to the hospital?
Yeah, so this topic was covered in the DCR talk really expertly, and I thought that was actually very helpful. So law enforcement are very frequently the first responders to mental health crises, and of course that leads to certain challenges given law enforcement's role. And so they very frequently are the ones who are going to detain the youth and bring them into the hospital, and then initiate that process of the initial detention and evaluation, or simply shunt them into, the juvenile justice system, and that creates another set of challenges and potential interventions, which would be its own talk. But indeed, it's not infrequently the case that we have law enforcement officers being the first responders, and then these youth will either end up in the emergency department to be evaluated, which is ideal, or they will end up in the juvenile justice system and then ultimately arrive at a place like Echo Glen, for example, where their treatment will continue.
Okay, thank you. The next question kind of raises this idea that sometimes we have, clear laws and parameters for one service that might not align with another. So this writer says, one barrier our youth mobile crisis team has found is that youth have their own rights to seek inpatient treatment, but they cannot take an ambulance ride without their parents' consent. Do you see any ability for minors to consent to transportation to the emergency department for behavioral health treatment?
Oh, that's interesting. Yeah, I was actually not aware of that, and I think this speaks to the very frequently encountered challenge of the right hand not knowing what the left hand is doing. So we have these systems that have sort of been designed in silos to execute or to serve a very field specific set of needs. And those needs don't necessarily talk to the other needs in these other systems. So I think it would be a very good idea to sort of align at least several of these pathways. So if a youth is able to admit themselves to the hospital for treatment under the AIT, one would imagine that they should be able to consent to a hospital, or rather an ambulance ride to get to the hospital. So it's a very good point, and that is a challenge that hopefully we'll be able to resolve with talking into other fields more frequently.
Yeah, so often we're siloed, and just learning about kind of the upstream and downstream effects may lead to further discussion. Absolutely. Let's see. You brought up that there can be positives to hospitalization, but certainly it can be traumatic and it can be difficult for others. Do you have any recommended resources or literature that speaks to kind of the negative consequences of involuntary hospitalization for youth?
It's a very good question. I don't have literature resources off the top of my head that I would recommend, but I'll look into that, and maybe at the panel discussion I can suggest something.
Okay. Here's another question, specifically around family-initiated treatment. This author writes that their understanding is that doctors and facilities can actually opt out of or opt into family-initiated treatment. Um, Kind of curious if that is really the legal standard and how might we address this to get more options available if that is what's available.
Huh. Um, that's a very good question. I think this speaks to the sort of uneasy balance that we very frequently have to strike. And if a facility does not feel that it has the ability to strike that balance in an equitable way or a justifiable way, then it may end up that again the facility sort of opts out, and that is difficult because that leads to a dearth of access in an already very impoverished field of access and need. So again, there's not an easy answer to that, but I think that's something that does bear further discussion.
So many of these questions really, I think, get at, competing values and interests. This next question, I think, is perfect for somebody with child and adolescent training like you, Dr. Silver. The author asks, how does a child's developmental capacity really to make decisions factor into the equation, their ability to adequately consent, if you will, to hospitalization or not?
It factors in very heavily. I mean, that's an excellent question, and this is one of the benefits of having this done in a team sort of environment, because when we can, we certainly do want to draw upon the insights of, yes, a child and adolescent psychiatrist, but I'm frequently reaching out to developmental pediatricians and asking them questions about how they think the neurobiology is going to come into play here, even if we have school records or some sort of recognition of what other sort of co-occurring learning disabilities or intellectual impairments this youth may have. That's also going to come into play. So it's vitally important to recognize to what level this child or adolescent in this case is able to understand what the options are and make an informed decision in conjunction with the rest of the team giving medical opinions.
Okay. Dr. Silver, there's so many comments here. Thanking you for your excellent presentation and thoughtful approach. Another question here is, how often have you seen adolescent-initiated treatment, and how do outcomes differ for AIT from FIT, if at all?
Yeah, again, that's a great question. So to be honest, adolescent-initiated treatment is less common than the family-initiated treatment, and it's because very frequently youth don't recognize that there's an issue, or the fear that they have of the discomfort and the stigma and other issues overrides their even some recognition of the benefits of hospitalization. But we can intuitively recognize that when the youth's interests are aligned with or rather, the youth's voiced opinion is aligned with the opinion of the clinicians attempting to serve that youth, that then leads to voluntary admission, that the outcomes would be better, that there would be more cooperation with treatment, that there would be more reliable follow-up in the outpatient setting after the admission, and on and on. So the outcomes generally are better, but I don't have off the top of my head specific statistics to demonstrate that.
Sure. We often see several questions about how to access care if you're not already involved with mental health, specifically for youth who may not be yet at the point of needing hospitalized care, but certainly need to get seen and evaluated by mental health. Do you have suggestions where youth themselves or family could turn to start investigating these resources or get connected to care?
Oh gosh, yeah, that really is the $1 million question, because again, our resources are stretched so thin. The best recommendation I can give is to establish care in some way. I mean, even if it is talk therapy, or the so-called psychotherapy, when you think medications are necessary or what have you. The point is very frequently, patients and families are put on wait lists, which is unfortunate, but it's just a consequence of where we are in society and the resources that we have, not being equal to the task of serving the population. So if you are on a wait list, please just do your best to get established with some form of treatment, because when you have that form of treatment, then that acts as another advocate for treatment. And it adds in yet one more team member, to this growing team of support that you're wanting to build for the child or the adolescent. So that's my best suggestion. Just if you are on a wait list, that's great, stay on the wait list, but then find another avenue so that you can have some form of treatment while you're waiting for that other form of treatment.
Excellent point. Sometimes you just need to get connected, and that can get things rolling. Absolutely. This next question, I think, will help summarize some of the concepts you've already discussed. Can you provide some clarification regarding the RCW and the requirement to explore less restrictive options before referring to a DCR for ITA? For example, where would FIT fall into the order of less restrictive options compared to adolescent-initiated treatment and the child crisis outreach response and ITA?
So it's a sophisticated question. I think I understand it. So it depends on who's asking the question. So if it's a parent, that's going to be a different answer or a different kind of exploration of least restrictive alternatives than it would be if a social worker is asking it versus a physician asking it. But maybe I could just give a 10,000-foot view and say that as a clinician, because we are tasked with consistently keeping this concept of least restrictive alternative in mind, we're always moving with that in the back of our minds with regard to how quickly can we step someone down, what options are available in the community that we can either keep the youth connected with or step the youth into as quickly as possible after the discharge from the hospitalization.
Okay. I think we have time for probably one more question or so. Dr. Silver, you had mentioned that you had trained in Missouri and familiar with a little bit of law outside of Washington. And we're curious if you have any ideas about best practices for civil commitment, maybe in exploring how other states have approached the topic.
Yeah, again, that's great. We have to keep in mind that my forensic training was actually on this side of the Rockies. And so while I do have some understanding of the law based upon my training in Missouri, it was not as in-depth or sophisticated as my forensic training once I got to the latter stages of my medical career. But what I will say is that there are pros and cons to the process of civil commitment, and really all of the approaches to the various challenges that we face in medicine and in society that the law takes in various states. Shadow Jones talk was actually excellent in commenting on how there are benefits and drawbacks to every approach in every state. And so, there really is no one right way to do it per se, and certainly no perfect way that you can identify just based on a survey of the various states' approaches. I will say that there are some benefits to the speed of care and the seamlessness of admission followed by additional care when it's simply decided that under the age of 18, parents have full authority over their children to make decisions. Again, though, speaking to this concept of a double-edged sword, the challenge with that is that the youth then feels that they truly have no autonomy, they don't have a voice, and the expectation is much lower that they will want to follow up and want to engage in this care because they didn't decide to engage in it to begin with.
Excellent points. I think that will probably wrap up our questions for today. For all participants who did submit a question, thank you very much for doing so. We are banking all of our questions, and we'll hope to post some of these questions to the panelists at the June talk. And then just want to remind participants here today that our next talk will be in 1 month's time. And at that time, we will be talking about policy perspectives. We'll be hearing from Senator Dhingra, and she'll provide a brief history of Washington's civil commitment laws, recent policy changes, and investments along the entire continuum of care for severe mental illness, including aspects of our 988 system and the forensic mental health system. We also encourage everyone today to participate in helping our future events and giving us some feedback by participating in our post-event survey. And with that, Dr. Silver, thank you so much. We really appreciate your participation, excellent talk, and thoughtful approach to this very complex and sensitive topic.
My pleasure. Thank you very much for having me.
Thanks, everybody.